to the cloud. And I will start. All right, we will let people start to populate. And once we see people logging in, which we do, I will begin. Welcome everybody to the final panel of our 2021 Spring Symposium for the Wayne Law Review. My name is Worman. I'm the symposium editor and a 4L, almost graduating from Wayne Law. I want to start out by thanking our editor-in-chief for this year, Kylie O'Brien, and all of our student editors and editorial board. We are very excited for today's conversation and for today's discussion. And we have a very good panel ahead of us. I want to make one quick note that the views expressed by our panelists, just as part of Wayne Law Review's policy, the views expressed by the panelists do not reflect those of the university or the law review. We do that to really promote intellectual diversity and thought. So without further ado, I want to introduce our moderator, former Speaker of the Michigan State House and current partner at Plunket Cooney, Tom Leonard. He was Speaker of the State House from 2017 to 2019, and he will lead today's discussion on federalism, COVID-19, and the intersection of state emergency management laws. As the Speaker of the State House, he was the leader of the state legislature, interfacing with the governor during those times, and has a pretty good understanding of the separation of powers at the state level. So with that, I will spotlight Tom and hand it over. Thanks, Tom.
All right, Will. Well, thank you very much for having me. It's an honor to be here this afternoon. Will, thank you for putting this on. I want to thank you. We've got a very distinguished and great group of panelists who I'm going to be introducing here very soon, and I want to thank all of those that have tuned in. But as you know, this is the topic that is dominating the day. This is a once-in-a-century pandemic that has hit our nation, has hit the world. And it's going to have consequences for decades to come, especially on the legal side of things. You know, particularly here in Michigan, we've seen hundreds of lawsuits, and I'm sure we're going to see some of these that are going to change the state of the law for decades to come. In fact, just a few months ago or several months ago, the legislature, as many of you know, sued the governor. And for the first time in recent memory, the Supreme Court actually ruled, based on a legislative lawsuit, that the governor's actions were unconstitutional. So this is going to continue to have legal ramifications and changes in the law for, you know, here on the state and federal level for decades to come. So certainly a very interesting and important topic to discuss. And again, I'm glad to be here and be part of it today. So what I'm going to do is I'm going to introduce our panelists one at a time. So what I'll do is I will get into our first one, who is Professor Wurman. And Professor Wurman is an associate professor at the Sandra Day O'Connor College of Law at Arizona State University. He teaches administrative law and constitutional law, and also writes on administrative law, separation of powers, and constitutionalism. And Professor, again, it's an honor to have you here today. So I'm going to open it up, give the floor to you, and you know, let us know what you have to say.
Great. Well, thank you so much for hosting this panel and for having me on it. My remarks are more about the separation of powers than federalism, though of course federalism is a subspecies of the separation of powers, right? I mean, so it's all related. But in my time, in my few minutes, what I'd like to do is actually discuss the amount of deference that courts ought to give to governors exercising unilateral executive power. My remarks are not about, you know, well, our court's public health experts, our governor's public health experts, what the public health response should have been, could have been, would have it been. It's none of that. It's about the constitutional separation of powers in a system of separated powers, who should be making decisions like this? So my claim is that in many, not all, but in many COVID cases, courts should not have given rational basis deference to governors. So to the uninitiated, rational basis deference makes it almost impossible for the government to lose. So long as a rational legislature could have a conceivable reason for taking the action it did, it's upheld, even if that wasn't the actual reason that was motivating the legislature, and even if evidence, whether adduced at trial or otherwise, suggests that in actuality the action was quite unreasonable, right? As long as it's conceivable that some rational legislature could have a conceivable reason for doing this, it's upheld. Well, to stake out my claim that rational deference, rational basis deference was not appropriate in many of these cases, I want to briefly summarize my research on the police powers in the antebellum period and how courts reviewed exercises of the police powers. And here I mean police powers to regulate the health, safety, welfare, and morals of the people. It's just the regulatory power of the state, if you will, the legislative power of the state. And then I'll talk about how those antebellum doctrines of judicial review of police powers translate to two areas related to the coronavirus pandemic. The first has to do with these delegations of police power to governors, these delegations from the legislature to the governor. And the second has to do with enforcement of state privileges or immunities clauses. And maybe, by the way, eventually the federal privileges or immunities clause, which I'll get into. So in my prior research, and I have a paper on this in the University of Chicago Law Review called The Origins of Substantive Due Process, where I examine antebellum police power cases. And what I discover is that they don't stand for the proposition for which they are ordinarily thought to stand. I argue there was no substantive due process in antebellum law. There was no general reasonable limitation on state legislature, reasonableness, I should say, limitation. There was no general police power limitation on state legislatures. The legislatures theoretically were limited to reasonable exercises of the police power, and the idea that they were theoretically limited to doing things in the public good. But court after court after court, treatise after treatise after treatise says it was within the legislative wisdom to determine what was a proper exercise of that power. So call it the antebellum rational basis test, if you will. By the way, I don't even know if rational basis is appropriate. It was really no review in a way. It could be totally irrational. It doesn't matter. There was no express constitutional limit. If it was the state legislature, it was up to the states to decide what they thought was within the police powers, what they thought was for the common good, safety, public welfare, and so on. Having said that, there were a variety of police power doctrines that are relevant. So the most prominent had to do with delegations of authority to municipal corporations. So when the legislature delegated power to local governments, to municipal corporations, the judicial courts did police their exercises of power to ensure reasonableness, to ensure that their exercises of power were not in restraint of trade, and that they were genuinely for police power purposes. So the idea here was that their authority, the authority of these municipal corporations, was limited to those powers expressly delegated by the legislatures or necessarily implied. This, by the way, is still current doctrine under municipal government law, local government law. That's still the doctrine, I think, everywhere in all 50 states. So if a municipal corporation, that is a city or a town, was exercising power pursuant to a broader delegation of authority, the courts reviewed their acts to ensure reasonableness and that they were legitimate exercises of the police power, again, on the theory that the legislature would not have intended to delegate the power to act unreasonably. Now, if the legislature did expressly delegate a power to do unreasonable things, there was nothing courts could do to stop it. So we're talking about general delegations of power and acts taken under those general, broader delegations of power. You know, make a regulation in the public health or something like that. This doctrine, by the way, also made some sense, right? The legislature gets deference when making policy decision, but the legislature is also checked and balanced, usually by another branch of the legislature, also by the executive. There's a separation of powers, not so at the local level, not so at the local level. Local city councils can exercise combined legislative, executive, and judicial powers, right? So it's very, very different. So it might make sense that courts should review their acts for reasonableness and to ensure consistency with the delegation of authority. Okay, there were two other doctrines they related in which the state legislature itself was in fact limited to reasonable exercises of this police power, but it wasn't a general limitation applicable at all times. It only applied where state power came into potential collision with express federal constitutional prohibitions. So one such prohibition was the Commerce Clause, which in the antebellum period was presumed to be exclusive to Congress, meaning the states could not regulate interstate commerce. This became the Dormant Commerce Clause eventually. Now, what do you do when a state regulation that seems to be a police power regulation affects interstate commerce? Like a quarantine law. A quarantine law, by definition, affects interstate commerce, but it also kind of looks like for the public health and safety. So what do you do? What do you do if there's a prohibition on regulating interstate commerce? Well, what the court said was that they would uphold the state regulation if it was a genuine and frank exercise of the state's police power. If it was legitimately for a police power purpose, then they would call it a regulation of police, which was permissible, as opposed to the thing that's forbidden, like a regulation of interstate commerce. If it was unreasonable, if it was just a guise to discriminate against interstate commerce, that would not be allowed. But if it was legitimate, frank exercise of the police power, then it was fine. A similar doctrine, by the way, existed for the Contracts Clause, right? No state shall impair the obligations of contract. A similar doctrine existed. Okay, so what does this teach us about the police powers today in the COVID-19 pandemic? Well, I think two things, starting with delegation. In Arizona, where I am, we have a statute that delegates to the governor all police power of the state in the event of an emergency. Now, putting aside the non-delegation doctrine, which I raised in a lawsuit, sorry about that, that I raised in a lawsuit that I filed on behalf of bar owners across the state who we think were discriminated against. For present purposes, my point is different. It's not about non-delegation. What we argued, and what I argue, and what I argued in my scholarship, and what I argue in the symposium essay for this symposium, is that if police powers are delegated to the executive does not, or at least should not, get the benefit of the rational basis test. Only the legislature should get the benefit of that test. The executive is more akin to a municipal corporation. The executive doesn't have to deliberate with anyone like a legislature does, like legislators do, I should say. Executives aren't checked and balanced by anyone. What principle of law says that the executive should get as much deference as a legislature, at least when exercising a power pursuant to broad delegations of power from the legislature? So maybe to put the point more colloquially, why should one woman or one man acting alone get such immense deference? The courts, in other words, we argued, and I argue, should rigorously ensure that the executive is complying with the delegation, just as municipal corporations are reviewed. Because again, surely the legislature doesn't intend the executive to act unreasonably. The executive doesn't have the same checks and balances that a legislature does. And that's implication one. Implication two, I think, is for at least discrimination claims under state privileges or immunities clauses. Perhaps, by the way, this will apply one day to the federal privileges or immunities clause of the 14th Amendment. I argue in my new book on the 14th Amendment that this clause is in fact an anti-discrimination provision. It in fact was supposed to do the work that everyone thinks equal protection does now, or that what we say equal protection does now. Well, my findings from my antebellum research suggest again that there was no substantive due process. So Lochner was wrongly decided. It was for the legislature to decide the wisdom, I think, of the maximum hour laws for bakers. But just because Lochner was wrongly decided doesn't mean that Slaughterhouse was rightly decided. So in Lochner, we had a general regulation applicable to everybody, but in Slaughterhouse, there was a discrimination. Similarly situated citizens were treated differently by a grant of a slaughterhouse monopoly to a group of favored butchers. Monopolies, by definition, were discriminations of common law. A monopoly literally gives more privileges and immunities to certain citizens that it arbitrarily denies to other similarly situated citizens who could equally participate in that occupation or that industry. But they can't because of this exclusive legal privilege that's given to a certain set of other Americans. Well, so I argue, and I've argued in my scholarship, and again in this essay, that the Privileges or Immunities Clause also requires a police power analysis by the courts when there is an alleged discrimination, such as in our case. Again, in our case, just to be clear, if you think bars should be shut down, fine. That's not what I'm arguing against. I mean, one argument again is the legislature should make the call, and the other is in our case, our governor allowed breweries to stay open, hotel bars could stay open, restaurants and restaurant bars could stay open, private clubs could stay open, okay? All while the governor in our state scapegoated a couple of bars and closed them down. So we argued, look, if there's a discrimination that is covered by the specific constitutional text, the Privileges or Immunities Clause, that must be justified by a legitimate and valid exercise of the police power. Otherwise, it comes into collision with an express constitutional prohibition, the express constitutional prohibition on abridging the privileges and immunities of citizens, which is just as express a prohibition as the prohibition on regulating interstate commerce or impairing obligations of contract. So in summary, one might say, or at least I argue, that the rational basis test only applies, or at least should only apply, to actions of the state legislatures. That's claim one. And claim two, it should only apply to substantive due process claims, to unwritten constitutional limits. I don't think it applies when governmental actors are exercising delegated police powers. And I don't think it applies where those police powers come into potential conflict with express constitutional prohibition, such as the prohibitions on discrimination. So to conclude, I think, there was no substantive due process in antebellum law, and, substantive due process in the Lochner era was likely a mistake. I don't think courts should be sitting in judgment on the reasonableness of general regulations imposed by a legislature. But the police powers should still play a role, in several parts of modern law, the law of delegation, and I think the law of discrimination. I think these historical sources that I've mentioned suggest that in many of these cases with which courts have dealt over the past year, the courts should not have deployed rational basis deference, at least not so quickly. They should not have abdicated the judicial role so easily. And that's my claim.
Thank you very much, Professor Wurman. And I wanted to make certain that everybody knows, I did see that Will did post in the chat function. Please know that when we get to open discussion here in just a little bit, we would love to have audience participation. So if any questions are raised, please feel free to type those in there now, and I will do everything I can to get to those when we have open discussion. So with that, I would like to introduce Patrick Wright, who currently serves as the Vice President of Legal Affairs for the Mackinac Center for Public Policy. Aside from directly representing clients, Mr. Wright has filed numerous amicus briefs, including many to the United States Supreme Court. Recently, the Mackinac Center was involved with Grand Health versus the Whitmer legislation. He had a very instrumental role in that, and I believe he's going to discuss that as well. So with that, Mr. Wright, thank you for being here.
Thanks for having me. I appreciate the opportunity to speak with everybody. Grand Health was our case. We filed it. It was the case that was argued in front of the Supreme Court. We hired the attorneys, worked with the plaintiffs, developed all the oral arguments. So I'm very familiar with it. And I guess I want to talk about the non-delegation doctrine, which Professor Worman said that he brought up and was, I guess, unsuccessful with in Arizona. We were successful with it here in Michigan. I think it puts us kind of in three phases in Michigan. The first phase is where the governor was looking at the Emergency Powers of Governor Act, the Emergency Management Act, and the Health Code. We're in the second phase right now where we're using health code emergency orders, and just recently MIOSHA has announced a preliminary rule set, which I think is going to be our third phase going forward. And I'm going to talk a little bit about how non-delegation either does or doesn't apply to all of them. In March of last year, I think it was on the 10th, is when we had our formal declaration of an emergency in Michigan. The governor used two statutes at that time. One of them was largely created as a response to riots in Detroit in 1943, and that was the Emergency Powers of Governor Act. It had very broad powers that it was given to the governor in times of an emergency. The second one, and it didn't have a time limit to it. So there wasn't a situation where the governor had to go to somebody else and say, okay, hey, is the emergency still ongoing? And the governor, in this case herself, says when the emergency ends and when these powers have to be relinquished. The second statute did have a time limit to it. It gave an original about a 30-day emergency powers to the governor, and it had a 28-day time limit to it that it could be extended, or unless the governor got the legislature's permission to go further and longer. So in response to COVID, the governor put out about 192, actually minus a couple because some of them were non-COVID, but 192 executive orders that were governing everyone's day-to-day conduct. They went as broad as a claim that she had the power to keep emergency powers until such time as she was able to fix the economy from any of the of ill effects that were occurring because of COVID. And so when she sought and was refused the right to extend an emergency, what the governor did was she said, okay, I'm going to, as the EMA requires, I'm going to call this emergency over. I'm going to immediately announce the same emergency, and I'm going to continue to use all the powers under the Emergency Powers with Governors Act, the Emergency Management Act. Now, the legislature already had a suit, or soon thereafter had a suit. We filed a different one. They went the state court route. We went through federal district court and essentially had our questions certified over in the Michigan Supreme Court decide them. So what eventually happened is we put forth a bunch of arguments as to why the Emergency Powers of Governors Act was being read too broadly, that the governor didn't have all these powers. The majority of the court rejected that. They said, no, this thing is, it's not limited just to riots. It's not something with the public health versus public safety. This statute says she has the full extent of the police power during times of an emergency. And the words, the only limits were reasonable and necessary, were the only two words to protect the public health. To protect the public safety. And so the court looked at that and said that that was an extraordinarily broad delegation of power. There was no real time limit to it. And they said that as the power and breadth increases, the standards have to increase. And three justices said, look, there are no standards. Reasonable and necessary are vacuous words that don't really put any limits on the power. Ergo, this thing violates the non-delegation doctrine. A fourth vote would not have reached that question had he been able to avoid, and that was Justice Viviano. And Justice Viviano said, I can read this statute more narrowly. As a matter of fact, I think you should read it more narrowly. I think public health and public safety are different. I look at this as a riot statute, not a general pandemic relief statute. The governor should have used the health code, but didn't. However, since all my other colleagues are addressing the non-delegation doctrine and the constitutionality, I will do so as well. If you read the statute as broadly as everybody else seems to read it, then this statute does violate the non-delegation doctrine. And so that's essentially how Midwest Health played out. The remaining three justices all gave some iteration of the non-delegation doctrine is at least at the United States Supreme Court, had one very good year, 1935, and really hasn't been used since then. Now, that's not true in the lower courts, and it's not true in state courts, where a non-delegation claim has about the same odds as any other constitutional claim that's put forward. But at the Supreme Court level, it has not done nearly as well. You are starting to see some rumblings from the United States Supreme Court in the Gundy case and Whitman Trucking and so forth, that they are thinking about looking more at delegation administrative power generally. However, those things were just breadcrumbs at the time that Midwest Health was decided. So what was happening in our case and why we chose the plaintiffs we did was one of the orders that the governor did was that she said quote, non-essential medical services, unquote, were going to be prohibited while we were trying to flatten the curve and while we were worried about what was going to happen in the hospitals, that we were going to flood our hospitals and that that this would be so contagious, COVID, that we would spread it through having other people unnecessarily come. And so the reason we chose other health providers is obviously the state interest here is immense. We're at, depending on the numbers you look at, as of today, we're either at 16,731 or 17,800. I can't remember which one's more accurate right now. COVID deaths in Michigan were over 565,000 in the country. And so, obviously we're dealing with a very important public policy issue. Be that as it may, there are costs and benefits to some of the choices that were made. When you're prohibiting people from visiting their doctors, you're prohibiting cancer screenings, you're making it harder to find heart disease. There are people that have psychiatric needs. And there has been some scholarship that's looking at the questions of, okay, well, how many lives did we trade off by doing this? And so part of what we were doing in filing the suit was the economic, obviously the economic well-being of people matters, but we wanted to have something directly where we were saying, you're trying to save lives, and yet there's a possibility that you're costing lives here. And so that went into how and why we filed the suit. Another thing that was important, and Professor Wurman's stuff kind of touches upon this, is the rational basis test. Most of the federal constitutional claims have performed extremely poorly in challenging COVID. The only ones that have gone anywhere are essentially church attendance. I think we're on our 5th now Supreme Court case about whether or not limits on church attendance are or are not permissible. No other type of case challenging COVID regulations has made it made it through the federal courts and been granted relief at the Supreme Court. So really what you're left with for those people that are challenging are your non-delegation, mostly state constitutional claims. Now, that's essentially phase one. Again, now we're in a different phase. What happened after the Grand Health case was decided on October 2nd of last year is the governor reverted to using the health code. And if you Venn diagram some of the orders that have been done by the Department of Health and Human Services in Michigan and what was being done under the EPGA, you're going to see that there's a lot of overlap, but not complete overlap. And so what's happened is that the health code itself is a little bit more limited. It talks about public gatherings. It talks about the abilities to do this stuff in regional areas. It's just a little bit more detailed and has a little bit less broad powers. And that takes it, generally it's thought, from one side of the non-delegation doctrine from being unconstitutional to being more permissible. And at least it looks like that when one reads Justice Viviano's opinion. He was, of course, the fourth vote who said that the EPGA was unconstitutional. The three dissenters would have allowed even the EPGA, the governor, to do whatever she claimed was necessary and proper under the EPGA. And so when you read those together, it looks as if Justice Viviano is saying, if you go through the health code, you're going to be on the right side of the non-delegation doctrine. He didn't say that explicitly, but that's how most people have interpreted it. Now, where that leads us is we do still have a bunch of emergency orders and emergency rules, and these are in some ways grading for the same problems that to many, for the same reasons that the original emergency order set was. And that was that these are being done by one political entity at the exclusion of largely the legislature. You have a legislature which disagrees to some extent with the actions that the governor has taken. And the governor saying, well, these statutes give me this power, I'm using it, and you've ended up in this large fight. They have been able to work together on occasion. The school opening was done, and obviously, this affects 1.6 million students here in Michigan. That was done by legislation. That wasn't done by the governor saying this is the way it's going to be. And they've obviously been able to work together on a budget. But by and large, there has been a fair amount of conflict still between the two branches. So what's going to happen next is there will probably continue to be some more conflict, because what's going to occur next is a formal rule set that was just put out by MIOSHA. And this rule set does, let me grab some of the highlights. It says employers must create a policy promoting remote work. Retail stores have to require face coverings. A restaurant and bars have to do certain things and still requiring 6 feet of separation. You have to have masks in any place that you might go for leisure, be it sports, entertainment, bowling alleys, arcades. Employers have to do health surveillance, including daily health screenings for all their employers. So this is going to be a permanent rule set. And this now has to go through the JCAR process in Michigan, but that has largely been, some of the teeth have been taken out of it, because it was found that anything that gives the legislature any type of legislative veto is unconstitutional under a case called Blank versus Department of Corrections. So that's where we are. The non-delegation doctrine is important. The administrative powers and administrative law questions remain important. The governor has still a large amount of power despite the Midwest Health decision. And I do expect that we're going to continue to see further conflict between the legislature and the governor as the legislature tries to have more influence over Michigan's policy in fighting COVID here in the near future.
Thank you very much, Mr. Wright. And we will go into our last panelist. But before we do, again, I just want to remind everybody, if you have any questions for those that are watching, please feel free to type those whenever you want, because in about 15 minutes, we will be going into open discussion with those questions. So with that, we are honored to have Bill Myers, Associate Professor from the University of Tampa, with us today. Professor Myers and his co-author, Professor Downey of Grand Valley, have been working on some studies between the US and Australian responses to COVID-19 and the influence of federalism on those policies. And I know that they also wrote a very interesting, if you will, essay, or they did a piece of work comparing Michigan and Florida. And certainly with the recent spike in Michigan that we've been experiencing, it's very in tune with what's going on today. So with that, Mr. Myers, or Professor Myers, I'd like to give you the floor.
Thank you very much, former Speaker Leonard. I just want to, on behalf of my co-author, Professor Downey, just want to thank Wayne Law for having us. Now, I'd sent some slides to Will to hopefully he's got those up for us. Thank you very much. And so, as former Speaker Leonard suggested, we've been doing a lot of work on COVID and federalism, comparing countries, specifically the United States and Australia. But we wanted to take a look really inside the United States to see how COVID has been playing out at the state level across states. And so, given that Davia's in Michigan and I'm in Florida, seemed like a good time to compare what was going on between the two states. So Will, if you can move to the next slide. So the first place we want to start is by acknowledging that public policy at its core is about government activity. The purposeful intervention in society, to at least in a crisis context, is meant to minimize the impact, the negative side effects of any crisis, to increase the capacity to respond to those crises, and ultimately to coordinate and manage a response to these crises. Will, if you can go to the next slide. Of course, we have been really confronted with the purposeful choice across many states in this country to do nothing. And normally when people are confronted with the purposeful choice to do nothing, when there's clear negative consequences, that is met with charges of people being negligent, irresponsible, and really as providing evidence of just ineptness. Now, of course, the United States, because it is a federal system, federalism is always going to provide a barrier to action. And so we might suggest that part of the reason why we've seen evidence of inaction across the states is really due to this fact that we just have authority carved up all over the country. And as a result of this, the state governmental actors, particularly executive actors, governors, they have been able to use federalism as a justification to do nothing. And this is consistent with how state governors, unfortunately, have been using their authority in the kind of more modern era, right? They're more focused on increasing their own political influence, maintaining state autonomy, rather than solving pressing public policy challenges. Of course, we should also recognize that the purposeful choice to do nothing can also be informed by an ideological commitment that views doing nothing as actually not only desirable, but actually the right thing to do. And certainly conservative and right-wing ideological commitments reinforce this idea. And the idea at its core is all about shifting responsibility from the government to actually respond in a crisis and shifting that responsibility to citizens. Because ultimately the idea here is that markets provide better solutions. And if we don't invite government in to use what can at times be exceedingly maybe draconian authority, well, this is the best way to maintain individual rights and liberties. And so again, from a certain political point of view, the idea that government would deliberately choose not to act is actually a good thing. Will, if we can go to the next slide, please. And so one of the ways that we can kind of start thinking about this a little bit more specifically is by thinking about the idea of executive underreach. And this is juxtaposed against the idea of executive overreach that we might be more familiar with. Executive underreach is simply an executive actor's failure to address a significant public problem that is both legally and functionally equipped to address. So again, this gets to the heart of the matter. They have chosen specifically not to act, even though they are empowered to do so. Of course, the United States is a hospitable environment for executives choosing not to act. There is a long and deep history in both constitutional law and administrative law that recognizes that executives have the authority to decline to enforce statutes and are allowed to not act. Part of this is based in the core ideas of negative liberty, how we conceive of the relationship between the government and the governed, and what our civil rights and liberties are. But the idea here is really that courts can only get involved in assessing government activity if government actually acts. But if government chooses not to act, then there is nothing that the courts can do. And of course, we should note that governors in 42 states, at least going back to the summer of June 7, 2017. So this is quite a few years before the current COVID crisis, all had explicit and fairly generous terms to be able to act in a broad variety of ways to meet any type of emergency that was facing the state. And so even in the last few years before COVID, we had governors using this type of authority in response to natural disasters, infectious disease emergencies, and the opioid crisis. And this includes governors from New York, Pennsylvania, but also Texas. So this is something that is happening across the states, regardless of what we might think of them in terms of their political proclivities. Will, the next slide, please. Well, one of the advantages of federalism, of course, right, is being able to allow the different states and our different executive actors to be able to have a wide variety of ability to figure out how to respond accordingly on their own. And so what we've decided to specifically look at is to look at the response of states with Republican legislatures. And then within that comparison, looking at those states with Republican legislatures that had Republican governors versus those states with Democratic governors. And of course, this corresponds to Florida and Michigan. But when we look at all of these states together, we can see that there were some differences in terms of their responses. So stay-at-home orders, for example, those started earlier in states with Democratic governors. Their stay-at-home orders lasted much longer compared to those states with Republican governors. The time where to start a mask mandate started much sooner, and the death rate per 100,000 people, at least through the end of November of last year, was just a bit higher in states with Republican governors compared to Democratic governors. Again, this is Republican governors and Democratic governors, but in states with Republican legislatures. Will, the next slide, please. And so what we want to start thinking about here is what types of actions could our executive authorities engage in? And we just try to think of these actions just very generally as closing and opening actions. And so we see some examples of what closing actions would be. So stay-at-home orders, closing or restricting business operations, closing K through 12 schools, quarantines for out-of-state travelers, face mask mandates, opening actions, again, ending stay-at-home orders, lifting business capacity limitations, requiring in-person instruction for public schools, and again, no travel restrictions. And the next slide, please. And so we decided that it would be helpful to look at some data. And so we've got daily cases in this slide for Florida, the next slide for Michigan, but we'll focus on Florida here for a moment. And again, we focus on cases because cases are the leading indicator, right? As President Trump, infamously suggested, if we stop counting cases, we won't have COVID. Well, that's right. And so what we can at least see in Florida is that Governor DeSantis, right, a Republican governor, was extremely active at the beginning of the pandemic and was at least as active as any governor in the nation in trying to close things down to protect the Floridians. Of course, what ends up happening is the governor starts thinking that we're in the clear and starts engaging in a series of opening actions, Florida's different phases of openings. And so we see two large spikes in cases, first in the summer, and then leading through the fall, closing out the year. In the first initial spike, Florida saw a jump in 413,070 cases, or 31.3% of its entire yearly total. When we see the movement in the second spike, that again is pushing out through the end of the year, this is after the last big phase of reopening at the end of September. This is where Florida's biggest jump happens. 612,903 cases, or 46.3% of its yearly total. And what we're showing here is that after each of the opening actions that the governor took, Florida saw 1,025,973 cases. 77.7% of the entire yearly total happened after these reopening actions took place. Well, if we can look to the next slide. And so now we can do, again, another comparison, but with Michigan, right? And we can see that Michigan was extremely lucky early on. And even into the summer, there was, again, seemingly all the reason in the world to start loosening restrictions, which Governor Whitmer decided to do. Now, of course, we don't know exactly why we didn't see a spike in the summer. We might attribute that to the fact that during the summer in July, Governor Whitmer, like many other governors around the nation, decided to issue a statewide mask mandate, but still things seemed to go fine. It wasn't really until a series of culminating opening actions in the fall that Florida saw a dramatic spike in their cases. And so during that spike, and then its steady fall through the end of the year, Michigan saw 371,837 cases, or 73.7% of its yearly total. And so, part of the reason why we're seeing these spikes, we would attribute to these opening actions. And of course, part of the reason why we believe that there was a dramatic decrease in cases is because of Governor Whitmer's decision to initiate what began as a 3-week pause in November that was ultimately extended through the holidays and into January. If we can go on to the last slide, please, Will. And so what I would just like to sum up with, if I may, is some information from Professor Maria Eisenberg, who is a mathematician and epidemiologist at the University of Michigan, who put together a series of modeling, right, to try to assess exactly what the pause to save lives brought to Michigan. How many lives did it save? Well, according to her modeling, that decision to close things down in Michigan resulted in at least 109,000 fewer cases and at least 2,000 lives that were not lost. In a recently published article in the American Journal of Public Health on the April issue, those epidemiologists rate what Florida's response has been. So from March to September. And what they note is a significantly big jump in the amount of excess deaths in the state that would normally appear, a 15.5% increase in deaths. And they estimate this to be at least 14,317 additional people dying as a result of Governor DeSantis's decision to continue opening up. And so as other panelists have been suggesting or noting, Michigan is currently experiencing a massive rise in cases. And all I would say about that is welcome to Florida. This is what happens when governors decide not to actually use their authority, to not actually close things down. And ultimately, Michigan is seeing the brunt of that choice. So that's all I've got. Thank you very much.
Well, thank you very much, excuse me, Professor Myers. And actually, it looks like our first question is for you, and I apologize, I've never, there we go. See if I can move this, is for you, and it comes from one of our attendees, and it says, and I'm just reading this exactly, it says, cases are a leading indicator, but they depend on testing. Michigan's cases declined through the winter, but the amount of testing declined by 40% as well. That seems to have a pretty large effect on the data. But overall, Michigan has had more COVID deaths than Florida throughout the pandemic. In the past 2 weeks, cases and deaths in Michigan have skyrocketed past Florida, despite having much stronger mandates. Does or how does this affect your thesis?
Well, yeah, I mean, I think that when you are looking at, you know, a lot of these other confounding ideas, it matters. Absolutely. What I would at least suggest, though, is that using cases is maybe the most conservative estimate of exactly what's going on in terms of COVID, right? We know that cases require testing, right? May be, again, leading indicators of hospitalization, ultimately death. But this is at least trying to get at, again, in the most conservative way possible, an assessment of what types of actions government is taking to try to limit all of these really bad other side effects, right? I mean, ultimately, government is trying to protect its citizens, and no one's going to die unless they get COVID. And so the best way to do that is to prevent the spread of cases in the first place.
I have a follow-up here, Professor Myers. I apologize. It's on yours as well. And then I'm gonna ask something to Mr. Wright in just a minute. But this is a question. It says cases may be a leading indicator, but we also know that cases are severely undercounted. Wouldn't testing positivity rates and deaths be better indicators of COVID spread and activity?
I think that was the first question you asked, sir.
Okay, I apologize. I'm on a different section of my computer. Let me go to Mr. Wright for just a minute. This is a question that I had, and I want to go to the Supreme Court decision in their ruling on the EPGA. Did it ever come up, or did the dissent ever indicate whether or not there could be any limits on the governor's power under the specific statute, or is it absolutely unlimited?
Well, the dissent would tell you that the reasonable and necessary to protect the public safety, which was what was listed in the EPGA, was a serious limitation. So they would say that that implies that there's some limits to what goes on. At oral argument, which by the way was, I can't remember if it was 2 hours and 45 minutes or if it was 3 hours and 45 minutes. It went on forever.
I remember it was lengthy.
Yeah, there was a lot of discussions about this. There was never really a situation where Mr. Restuccia, who was arguing for the governor, really came to a position of where he said, okay, this is what the limit is. He would point to those words and say, these are a limit in some way, shape, or form. So The dissent says it's a limit. It's difficult to see what you can't fit under reasonable and necessary. Again, as we're talking about, 565,000 deaths here in the United States, you can make an argument that anything is reasonable and necessary in order to prevent the loss of life. How many losses of life, how much loss of life would we allow is a difficult question.
So I remember having this debate, and I'll be very frank, it was with an attorney much smarter than me. Okay, it was about a week before the case came out, and I think a lot of people were anticipating that maybe this case would come down 4-3 the other way. I know there were many folks and attorneys that thought that this was going to go the other way, 4-3. But this attorney that I was having this debate with, he had taken, I guess, the minorities or the dissenting opinion on this. And I asked him about these limits. And I said, under this legal theory or this argument that this statute can just be used indefinitely and it's this broad, could the governor conceivably, and I don't believe this would ever happen, but it was just my hypothetical. As attorneys, we love those. I said, hypothetically, if this pandemic continues through the 2022 election, could a governor conceivably, under these types of powers, cancel elections and continue to stay in power indefinitely? Did you meet any legal scholars or attorneys or judges, maybe not with that specific example, but took that kind of view that, hey, this is indefinite power and there is no end to it?
Well, that's how the majority and I take that back. That's how the plurality interpreted it, and by and large, how the dissent interpreted it. That the governor had extraordinary powers, could do what was necessary for as long as the emergency went on. We had tried to argue in interpreting the statute that the emergency at some point stops being an emergency and just becomes a really, really, really important public policy matter. And that the need for immediate action on the part of the executive goes away, and we can start having the legislature chip in more. The Supreme Court rejected that argument. They said an emergency is an emergency until it's no longer emergency under the definition of the statutes or under a normal reading of the word emergency. We didn't deal with that particular concern. The one that got me is, how many different things can we have an emergency for? Before COVID came about, the governor was looking to have a vaping emergency, that there was too many young people that were smoking these quasi cigarettes or whatever the heck vaping is. Okay, and therefore she was going to use this statute for that. It doesn't take much imagination to come up with other emergencies. If I'm a Democrat, is there not a climate emergency? If I am a Republican, is there an abortion emergency? What if you're going to say that you can trigger this fairly easily, and that the governor is going to be responsible for saying when these emergencies end, and that you have this broad swath of powers, you can see that this statute is fairly dangerous, which is why I think the Supreme Court clipped this particular statute. And I think Justice Viviano, again, became the tipping point and has probably said, you can do a lot of what you're trying to do here under a pandemic situation, but you're going to have to do it under the health code.
I had a question just pop up, and it looks like this question is for Professor Wurman. And it says, a question for Professor Worman: what do you make of Professor Myers and Downey's work in relation to the legislature being too slow to address emergency issues, and how rational basis might apply when the legislature could be viewed as simply too slow to act?
Yeah, that's a terrific question. And really, the reality is it illustrates how this so-called emergency, and again, I don't want to say it's like not a threat or not an important public policy problem, including one that might lead, to deaths. Lots of public policy problems address, highway safety and what have you. The question is, in most emergencies, by definition, they're emergent in the sense that the legislature literally cannot meet to address them. and there would be nothing legislative to do. So if a fire, rampages through the state of Arizona, what does the governor do? He directs the emergency personnel of the state. He coordinates among the jurisdictions in order to suppress the fire. Private rights can be incidentally affected, as when you say, do evacuation orders or something like that. Maybe you can build shelters. Same thing when there's a hurricane, when there's an earthquake. They happen, and there's literally nothing legislative to do. It's all about directing the official personnel and conduct of the state. Now, here, as we've seen, let's put aside March and April of last year. What we've seen is this is different. Here, the legislature is not too slow to meet. They can clearly meet and address these public policy problems, which touch not just official conduct, not just, do we want firefighters to go to place X or place Y? Should we build humanitarian shelters? But they touch every subject under the sun touching the human condition, whether kids should go to school, whether renters should be evicted, whether there should be an eviction moratorium when renters don't pay rent, what businesses should be open, what businesses should be closed, right? These affect everything under the sun for an ongoing period of time, and the legislature is able to meet. So if that doesn't violate the non-delegation doctrine, then I don't know what does. And maybe that's the truth, that nothing violates the non-delegation doctrine, which is sort of the modern doctrine, and which is why we've argued sort of for a different conception of the non-delegation doctrine. So, that's my view of the matter. Now, going back to March and April, is it part of the executive power or emergency power or proper delegation, to shut everything down, including affecting private rights, as we learn more about a situation, like there's a new threat, we don't know what it is, and we're taking precautions? Well, that may or may not be constitutional. I don't know. Maybe it's a necessity. Maybe there is no choice. Maybe there's nothing we can do about it. But just because there's no choice, just because it's a necessity, just a reality of modern emergencies and government power, doesn't mean the courts, after the fact, have to go back and say it was constitutional and give some sort of constitutional imprimatur to it. This is kind of like what Justice Jackson said in Korematsu. He said, look, 2 years ago, who are we to question military necessity? If this case had come to us 2 years ago, I can't say I would have told the government that they can't intern Japanese Americans on the West Coast. But now, 2 years later, I'm not going to go back and say that was constitutional. Maybe it was necessary. Maybe there's nothing, we would have said at the time, but it doesn't mean after the fact we have to go and constitutionalize. And by the way, that's the only reason I bring up Korematsu, is for the parallel in that reasoning. Obviously, this is nothing like Korematsu in other respects. And so that's sort of my view on the matter. I mean, just to say the legislatures are too slow to meet and these aren't legislative in nature, I think just defies common experience and logic in the situation. And I think Professor Wright wants to respond to me or support me.
Yeah. Not to jump too far here, but I want to ask a question. I want to open it up to any of the panelists that want to jump in here. And that's in regards to, because we're talking about federalism today, this is in regards to a federal response. As we know, the year that, President Trump was dealing with this up and through, he was out of office. You continue to hear from his opponents or those on the other side, we need a federal response. We need a federal response. And some may kick back when I make this comment, but it seems like President Biden's response has generally been the same, and that is, hey, let's leave it up to the 50 states to come up with their own mandates and their own regulations and what have you. My question for you is, can you make a legal or constitutional argument either for or against a federal response? And when I say federal response, I'm talking about mandates or regulation, a nationwide mask mandate, a nationwide restriction on restaurants or limitation on restaurants. I guess the list could go on. Can you make a legal or constitutional argument either for or against some type of federal mandate or restriction as it would apply nationally?
Well, I do have a couple, thoughts on that really quick, and that is, obviously you have to have the statutes in place necessarily to do it. There is no inherent, at least I don't believe, and I don't believe the framers of either Michigan or the United States believe, that there is just an inherent emergency powers portion of the Constitution that allows the executive to do what it wants, when it wants, if it feels the need is pressing enough. I believe that we're really dealing with documents that are attempts to limit government power, not necessarily just have them kick in when somebody feels that they want to have them. On that note, then you have to look at, okay, what can you do? We know we've discussed the Michigan things. There's 130 something federal laws that indicate that there's some level of emergency power. I don't know all of them well enough to know if there is a single one of them that would allow perhaps a national mask mandate. My belief is probably not. If you look at the way that President Biden has acted personally and in his campaigning, in his stops and so forth, he is obviously very sensitive to the belief in that the masks are very beneficial, that we can do a lot of stuff if we were to keep things in Professor Meyer's terms more closed than open. And yet you haven't seen anything from the federal government, which leads me to believe, without having looked at all 136 statutes, that there's nothing there that allows it.
Anyone else?
I mean, I've never, and you know, again, this might just be me missing something, but I haven't heard a great rebuttal as to why there isn't a federal police power. And so certainly there's some echoes of this in a very early case, Champion versus Ames, colloquially known as the lottery case. And so, you know, if there's disease spreading from state to state, then why couldn't the federal government avail itself of its commerce power and stop travel? And if the federal government can force hotels and restaurants in the South to admit African Americans because they might be getting their napkins or foodstuffs from other places around the country, well then why couldn't a nationwide mask mandate be justified on those terms?
You know, it might be permissible to do it under the Commerce Clause power. The question right now is one in place? I mean, if you want to make an argument that tomorrow the House and the Senate should meet together and do the national commerce mask law, there is at least an argument based on how far we've stretched commerce power. You know, the traditional view has been obviously that the federal government is one of limited enumerated powers, but obviously we've over the 230 whatever years we're doing this, we've expanded commerce power quite a bit based off of what I think its probably initial intention was. Regardless, the question isn't whether we could. At least I didn't hear the question as whether we could. The question is right now is there something in place? And my understanding, just based off of actions, this is all implicit, is that there isn't. Otherwise, somebody would have brought that forward and tried it at this point. Whether it could be, that's another question. And I agree with Professor Myers that the Commerce Clause is extremely broad as interpreted by the Supreme Court.
No, if I could jump in, like I'm not sure. I think certainly what Professor Myers has suggested explains why under modern Commerce Clause jurisprudence, as the critics say, this effectively has converted a government of enumerated powers into a general police powers. You know, when I was in law school, my constitutional law professor said, look, the reality is today, if it doesn't violate the Bill of Rights, Congress can do it, right? So it's a very sort of different conception than the framers had. But if you care about, you know, the original conception, and if you care about modern doctrine, I still don't think the federal government has a general police power. I think Professor Myers is right. The logic of these opinions suggests that, well, doesn't it really? But if we're dealing with modern doctrine, you know, the court does distinguish non-economic and economic activities, the number of inferences that have to go on. I think they'll now look to traditional areas of state, sovereignty or state, control, and they'll say, look, public health is traditionally within the state. So could they possibly regulate restaurants because restaurants are economic activities and in the aggregate substantially affect interstate commerce? Yeah, sure. I think that's right. Could they impose a mask mandate? I don't think so. So that would be trickier. They can impose mask mandates on instrumentalities of commerce, which is why we have mask mandates on the airplanes, right? They can do that. That's the Shreveport rate cases. So there's still some limits, and so I don't think a mask mandate would be upheld, a general one, in court.
And Professor Meyer, just going back to you, just to clarify. So again, I don't want to put any words in what you said, but were you essentially saying, yes, Congress would have that ability under the Commerce Clause to pass some type of congressional, to act congressionally or federally, or do you believe that there would be something in place now to allow the president or the executive to do that without congressional authority?
So, yeah, I mean, there is nothing currently in place. It's certainly permissible under, again, a modern understanding of what the Constitution is and a fair reading of what the court has said. Even if you go back to NFIB versus Sebelius, right, as Professor Worman suggested, right, you might only be able to mandate masks if people were directly engaged in commerce, right? So going into stores, going into restaurants. But I would suggest that, according to just executive authority, President Biden could, right, mandate all masks to be worn on Amtrak trains and all flights that go across the country. And my understanding is that actually is in place. That is actually executive orders that is in place right now. And so certainly there are limits, right? And that would need, legislative authority to justify actions, but it's available.
I think the limit is that it's on federal grounds. So if it's a military bases, if it's on government buildings and things of that nature, I don't think that we've gotten to the point where the authority extends. And again, this goes back to the 136 implementing statutes of to what we'll call just general commerce activities. But Tom, if I might ask one question to Professor Myers, if that would be okay.
Go ahead.
Yeah, I was interested in the Florida numbers because I ran some envelope math today, and it looked like Michigan's death rate was almost the same. As a matter of fact, Florida's was a touch less. Now, how I did that is I just took total number of COVID deaths. I divided it by the 2019 census numbers, which were the last ones I had. Okay, and I ended up with Florida's death rate of per citizens was at 0.16%, and Michigan's was at 0.18, with Florida having 34,238 deaths and Michigan having 17,817. Okay, does that sound plausible to you? That is just doing deaths divided by population from 2019.
That seems eminently reasonable.
So the question I had a little bit is when I looked at one of your slides, it was that the Governor DeSantis's actions were responsible for an additional, I think, 14,000 deaths or something along those lines. That seemed a little high to me, given that that's almost, what is it? I'm going to say 3/7 of the entire deaths that have occurred in the state of Florida. And I guess I was wondering, how would we look at that in Michigan? Are we saying that there are no excess deaths in Michigan? If the death rates are so close between the two states, I guess I'm having a little bit of a question of causality here.
Yeah, so
and that goes with some of the spikes as well, because is it indoor versus outdoor? Is it that the summer months in Michigan, everybody's outside and that's why we didn't see a spike? Whereas I've lived in Florida, and for God's sakes, I'm not going to be out in July if I don't have to be, but I'm going to run outside if I can in November and in December. So If you could just address a little bit of that question, I would appreciate. Or I think if there's a question there.
Yeah, I mean, so like, I think the seasonality part of this is incredibly important, right? As you know, right? I mean, you know, when Michigan was seeing its first big spike in 2020, right? It was cold. Everyone's kind of like gathering indoors, right? So there's no opportunities to really be outside, right? You know, and maybe similarly, right? If we're thinking about Florida, right? When they were seeing their first spike, right? In the summer months, when it's ridiculous and awful to be outside, right? That's when most people are inside, right? That to me, that comes a little bit apart for the seasonality argument, at least in the Florida story, because the second spike, which was significantly bigger and longer and more sustained than the first one, is happening during our cooler months, when it's actually a delight to be in Florida. The numbers that I had quoted about those deaths came from an article from the American Journal of Public Health called "Analysis of Excess Deaths During the COVID-19 Pandemic in the State of Florida" that just came out in April 2021, and they note that there were 26,479 deaths officially attributed to COVID. And so what they're suggesting when you do historical comparisons, and they do a really magnificent job getting into the data and the numbers historically, that we were seeing way more deaths in the state of Florida than we've ever seen. Again, 15.5% higher than what we normally see, even in kind of like wild speculative terms. And so they're specifically attributing that spike to what we see with COVID, which
Now,
is
that
clearly
spike,
reasonable.
I'm sorry to interrupt. Is that
No, but-
spike, and I looked at the death numbers from 2019, and I'm not an epidemiologist, so
Yeah.
I'm just playing around with some of the stuff because I have interest in it, as I think every American citizen currently does.
Yep.
Is that over a 2019 baseline death number, or is that over what we should have seen based off of COVID numbers? So when we're talking a 15.5% bump, are we talking about that as a 2019 pre-COVID baseline bump, or are we talking a different kind of bump? Because that's unclear from my understanding so far of what you've presented.
So in their paper, they do two comparisons. One is they do it immediately to 2019, but then they also do an historical average from 2010 to 2018. And so to get exactly what you're talking about, right? This baseline for reference, right? I mean, are we seeing, you know, again, just a random erratic jump in numbers, right? Did Florida just get unlucky, right? Or is it something else going on? And their analysis, and I would say their careful analysis is suggesting that that spike is absolutely attributable to COVID, and because Florida has had, let's just say, suspicious problems with reporting data, they actually see this as an underestimation. And so that it could actually be significantly worse than even what they're finding.
Can I jump in here for a second?
Yes, I was just gonna say, I know Professor Worman wanted to jump in. Go ahead, sir.
Yeah, and so I want to bring this back, and we're running out of time, to kind of the legal elements of this, the law elements. And so I wanted to say two things. The first goes back to the other discussion, and then this discussion. So the first thing is, there is a statute on the books talking about federal response that says the following: 42 U.S.C. section 264. The Surgeon General, with the approval of the Secretary, is authorized to make and enforce such regulations as in his or her judgment are necessary to prevent the introduction, transmission, or spread of communicable diseases from foreign countries into the states or possessions, or from one state or possession into any other state or possession. Non-delegation problem, Commerce Clause problem as applied, maybe, right? But I think the authority is there, and that's the authority they cited for, the eviction moratorium, the CDC nationwide eviction moratorium. And so the authority is there, and the question then becomes, is that maybe a non-delegation problem? Is that maybe a Commerce Clause problem? Are they exceeding the interpretation of the statute? And then the only other thing I wanted to say about the discussion that the two of you were just having, again, from a legal perspective. And so to Professor Meyer's chart, like I'm fully prepared to accept, right, that Michigan did so well for so long because they were locked down, and then they started loosening up. I know there are some questions in the chat and comments in the chat that question, how open Michigan in fact has become and so on, but there's no reason to doubt that they've opened up more than they were right before, and this led to the spike. And that raises the question of, again, institutional separation of powers and who should be addressing these public policy questions. If the question is, look, we know that this is a new disease and people are going to get it eventually until everyone's vaccinated. And due to government control, by the way, vaccines that could have been available a year ago, or not a year ago, but 8 months ago, weren't available 8 months ago because, again, government's cautious, regulators are cautious, right? But again, the Moderna vaccine was made 2 days after the sequencing or whatever, right? So like it was there. And so the question is, okay, if it's going to be 18 months before everyone is vaccinated, and therefore if we close down for a period of time, we're going to open up at some point, people are going to start getting the virus. Isn't that a question for the legislature? Isn't that not a question for executive power, for emergency power? Like what that balance is, can we afford to close down for a whole year, knowing that we're going to get it anyway, unless we close down for 18 months when everyone's vaccinated, and there's only so much the public can bear in terms of lockdowns, right? I mean, 6 months is tough. 18 months is, there'll be riots on the streets, and so isn't that a legislative problem, I guess is my question, rather than a executive power problem or a gubernatorial problem? And that was rhetorical, though you can, of course, ask, respond.
If you want to pipe it or not. I know we only have a couple minutes left. I did have a question, and I guess it could be for any of the three, but I know Patrick is the one panelist that is from Michigan, so maybe this is best for him, especially given his history of the case. But going back to the Grand Health Supreme Court decision, as you know, there has been a pretty big shift on the Michigan Supreme Court since that was last decided. Have you heard any chance the Supreme Court would take that case back up or something very similar to that?
Yeah, I don't know that if they would or they wouldn't. What obviously happened for our non-Michigan portion of the audience, if there is any, is that a Justice Markman, who wrote the majority opinion, was aged out of the Supreme Court and was replaced by, and I'm forgetting the woman.
Elizabeth Welch.
Elizabeth Welch, thank you very much. And so the question is Justice Markman was a well-known Federalist. Would she vote the same way that he would? Probably not. If not, what does that mean for the Grand Health decision? Could it be eviscerated within a year? Could it be expanded? What would happen with it? Most folks have, I don't think, got to that, mostly because Justice Viviano was already the pivot point. And he had essentially said, you can do most of what you want to do under the health code. At least he implicitly said that. There have been, obviously, the Restaurant Association, I know, has made a couple of challenges. There have been a few other federal court challenges trying to pick up on the non-delegation doctrine. To date, none of them have been successful. So is it possible? I mean, I was a Michigan Supreme Court commissioner for about 4 years. Could they take a case and review this decision? Sure. I don't think that they're likely to, but that isn't any sense of a guarantee.
Okay. Well, thank you. I do know it is, we are getting close to that 1:30 time frame. So again, I want to thank all three panelists. This was very interesting and I think very important conversation to have. And certainly this is not the end of it as this pandemic continues. So with that, Will, I want to thank you again for having us, and I will turn the floor over to you to close things out.
Thanks, Tom, and thanks everybody for being here. That honestly exceeded my expectations. This was an absolutely incredible panel, and it will be available on YouTube and other Wayne Law social media sites after for people to revisit, because I know that a lot of the information that we discussed today is beneficial around the state and probably around the country. And so I'm very excited for what impact this conversation can have moving forward. So again, I want to thank former speaker Tom Leonard for moderating, Patrick Wright of the Mackinac Center. I want to thank Professor Worman. His essay will be in the 2021 symposium issue coming out later this summer. And then I want to thank Professors Downey and Myers for their contributions as well. They also have an essay detailing the comparison between Florida and Michigan in this upcoming symposium issue, which should be published later this summer. So with that, I want to thank Wayne State University for the platform. I want to thank Wayne Law Review for an incredible year and helping us put this on. And with that, hope everybody goes and enjoys their weekend. To all of the students watching, good luck with finals. And to all of the people graduating, make the most of it with your friends and family, because we spent a lot of time in law school. So just because we don't have an in-person ceremony doesn't make it any less special or any less of an accomplishment. So thank you very much, everybody.
Thanks, William. Thanks,